Hello, my name is David R. Schneider. I'd like to welcome you back to our series of videos on estate planning basics. This presentation is going to discuss wills and trusts and how we can avoid the probate proceeding. One of the major questions, or what I should say, one of the questions I'm asked most often is, can I use a will? Well, wills are very different from revocable trusts. First and foremost, a will only works when you pass away. A living trust or a revocable trust is working right now. It works while you're alive and when you're healthy. It works while you're alive and you become unhealthy or become incapacitated, and it works when you pass away. Another primary difference, if not the most important difference, is something called a probate proceeding. Most people that have any familiarity with a probate proceeding will race out and tell you, you need to avoid a probate proceeding. And they're right, you do. A probate proceeding is a court-authorized proceeding to administer the property of a decedent, a person that's passed away. A probate proceeding is a required required proceeding when three things are present. And these are called and rules. You have to have 1 and 2 and 3. Rule number 1, you must die. Well, that's actually not that hard to do. Rule number 2, you must own property in your own name when you die. Primary example, the home. Rule number 3, when you die, the property you own in your own name must have a greater gross value, not net equity, gross value of $50,000 in real property or $100,000 in personal property. Well, living here in Southern California, anybody who is a homeowner, their home, their land is going to exceed a gross value of $50,000, which means all homeowners must try to avoid probate, must utilize a tool to avoid the necessary probate proceeding. How are we going to do that? I don't like that. Why do we want to avoid a probate proceeding? We want to avoid a probate proceeding for three primary reasons. First and foremost, it's very expensive. The costs that are involved in a probate proceeding are based upon the gross value of the estate. And the most expensive part of a probate proceeding, me, the probate attorney. The probate attorney is paid a percentage of the gross amount of the estate. The probate attorney receives 4% of the first $100,000 of the estate, 3% of the next 100, 2% of the next 800, and 1% of the next $4 million. Off the top, first in line. This is money that your family, your children will not receive. So on $1 million probate proceeding, and $1 million again in Southern California is not that high, the probate attorney makes $23,000. Now, it gets worse. All probate proceedings have somebody called a personal representative. This is the person whose name we bring the probate proceeding in. This person could be the executor of the will, it could be uncle, a family friend, somebody who petitions the court to be in charge. They are entitled to be paid as well for their time and efforts, and they are paid on the same scale that the probate attorney is paid upon. So if the probate attorney is making $23,000, so is the personal representative. Now we've peeled $46,000 off the overall estate. When we add to that filing fees, bond fees, appraisal fees, publication fees, it's not very difficult to peel $50,000 off of our $1 million estate. And remember, we're talking about a gross estate. The equity might make the value of that estate much smaller, so those costs are much more significant. The second reason we want to avoid a probate proceeding is time. The average probate proceeding is going to take in excess of a year from start to finish. And during this time, we do not always have complete control over the assets. We might not be able to distribute assets to your family in times of need, as an example for, let's say, college tuition. And we have to tell the children that they have to wait or find a less expensive school or go get a job because the probate estate cannot distribute the assets. Third problem with a probate proceeding, it's a public proceeding. And during that time, we have to invite known and unknown creditors to present claims against the probate estate. Not only are we notifying Visa, MasterCard, Shell Gasoline to file their creditor bills, but we're also inviting the public to do so when we place ads in the newspapers presenting the probate proceeding. So we want to avoid this for you, and you want to avoid this for you in the worst way. How do we avoid the necessity of the probate proceeding? Well, when we go back to our 3 rules, we have to look at the causes. Remember, death, ownership, value. Well, unfortunately, I do not have any control over your death, and frankly, I have no control over the value of the property you own. But of those 3 rules, the one that I can control, ownership. When you retitle the assets into the name of the trust owns the assets and you do not. Therefore, when we look at the 3 rules of probate, we sever the rule of ownership and the probate proceeding becomes physically impossible. You cannot have a probate petition, a probate proceeding, without assets, without a probate estate, as it's called. So the living trust can help us to avoid the probate proceeding by taking ownership out of the mix. Other people ask me, well, what about a will? Why doesn't a will work? Why can't a will avoid a probate proceeding? Well, we have to look at the 3 components again. First and foremost, a will only works when you die. A will can only transfer property that you own at your death. So a will has already met 2 of the 3 probate triggers. So all we got to do is get value. If we clip the value, then the probate proceeding becomes unavoidable. So in recap, we always want to utilize a living trust as opposed to a will in order to ensure not only timely management, but timely transfer of the assets to our named beneficiaries. If you would like more information about this topic or any of the topics in our series of videos, or to book a free no-obligation consultation with me, please give our office a call, David R. Schneider, 805-374-8777, or please visit our website at drs-law.com.